Still people creeping in here, but because we have about 53 slides to go through today, I'm going to get started right away. Hello, everyone, and welcome. My name is Daryl Foster, of course, from the Condominium Homeowners Association, and we've got Heidi Marshall here from our Victoria office, who is going to be helping deal with the chat. Heidi's going to be sort of monitoring, maybe even answering the odd simple question for you, and then pitching me some questions at the end of the webinar. So we're going to keep questions to the end. Like I said, there's going to be a lot of slides to go through. Probably a lot of your questions are going to be answered. And then anything that's outside the scope of this webinar, feel free to ask it, and we'll probably get an advisor to follow up with you. So you can either email us or contact Heidi directly, and then she can flick it the right way. But that's about it. So welcome. This is the Taking Minutes of Meetings webinar. This is part of our series of webinars that we're doing. And many thanks to our sponsor. CML Properties is our sponsor for this week's webinar. So we really appreciate their involvement. And of course, this is part of our education pilot project. Our fall webinar series is sort of being put together to develop an 8-part series that's going to be sort of repeatable through our advisors. Pretty much anyone can help deliver this information to strata councils. We think it's really important to have the basics and a significant webinar series that sort of fits together. So this is number 3 in that series. But remember, the information that's presented and discussed today is not intended as legal advice or an opinion on the merits or questions raised by the participants, and you're advised to seek legal counsel independently for anything related to bylaw enforcement, bylaw interpretation, legislation interpretation, or any matters relating to contractual relationships. So now that we've got that slide out of the way, let's carry on. Summary of today's session. So these are all the points we're going to go through. The definitions and purpose of meeting minutes, who takes the minutes, who approves the minutes, where and how minutes are retained by the Strata Corporation, how long must minutes be retained, the role of minutes enforcing bylaws, the role of minutes in collections, the role of minutes in legal proceedings or CRT action, the role of minutes in communicating essential information to owners, tenants, and occupants. So we're going to cover off all those topics today. And certainly we'll entertain a few questions at the end. Hopefully we'll get through this. Hopefully we're going to make this about 40, maybe 45 minutes at the most. And we'll get through this. So what are meeting minutes? Minutes are a record of what is done at a meeting and not what is said. Again, capturing the conversations or observations outside of a motion or a resolution is frequently inaccurate, subjective, inserts opinions or defamatory observations, and leads to conflict and exposes strata corporations to court or tribunal risks. So it's very important just to capture your decisions. Any of the discussion, any opinions expressed really shouldn't be included. It is up to council to decide what they include, but you really do need to think about the content of your minutes from that business perspective of your strata corporation, the business of the strata. The minutes contain the wording of motions, resolutions, reports that are included with notice of general meetings or raised on the agenda at council meetings. So a significant, a lot of variation between general meeting and council meeting type reporting. Again, definition and purpose of meeting minutes. Meeting minutes provide the corporation with a record of the decisions that were approved by the eligible voters at the meeting. So it is a record of decisions only that's required. Decisions provide the authority to the strata corporation, council, and delegated agents, such as the property manager, to implement those decisions. So something that's really important is to give clear direction to your property manager or other owners or people that may be involved in doing things on behalf of the council that required a decision. Spending money, for example, you're authorizing an owner to go do something and to spend money, then you're going to need to make sure it's very clear in the minutes what that is, what kind of authority they have, and what the limits are. For example, the authority to spend money, right? Collecting special levies, enter into contracts, file amendments at land titles, commence a court or tribunal action, or purchase or sell assets of the corporation, or enforce bylaws are all information that needs to be clearly retained in a set of minutes. These are decisions that could be used later on, and we're going to talk about that in a while. So what must be recorded? Section 35 kind of gives you that list of all of the information that the strata is required to retain. And that includes prepare all records, including minutes of annual special general meetings, council meetings, and including the results of any votes. And that's really all it says. So the results of the votes are really all that's required to be retained in your minutes. Regulation 4.13, again, talks about retaining minutes for how long? 6 years. So you want to keep a written copy and recommend them to be retained in a posted or electronic version on a website. So a lot of the property management firms have great websites that allow that kind of tracking. They can even limit who has access to certain information and then throw general information out to, so council members can have their own little portal that they use, and then all of the information on Section 35 that would be available to owners, for example, could be also retained in a location available to owners. It's up to the strata, again, to work with your management firm, or on self-managed stratas, what you want to do is set up something possibly like a Google Drive. But you need to make sure that there's continuity between councils so that you're retaining this information. Yes, the slides, I see that popped up in the webinar. The slides are going to be sent out to you later on. Okay, they're going to be posted to the website. I just heard through the other room, through the wall. The positions of council members are set out in the standard bylaws of the Strata Property Act. They do not contain a description or duties or authority for each position. The Strata Council determines the role of secretary, minute recording position. The role may be delegated to the property manager or another party. It's really important to understand that council roles can be determined by the Strata Corporation. You can either do it through a bylaw, or you can just set up a general kind of how you operate type system. But it's up to you to determine how you govern yourselves. There are certain roles that need to be elected at the first council meeting. We're going to talk about those. Who takes the minutes? The role of the secretary is has the accurate recording of the resolutions, decisions, motions, and reports. You record the name of the person taking minutes, record the exact wording of all of the 3/4, 80%, and unanimous votes in the minutes. So that exact wording is important. This is especially important for general meetings, to record who is actually acting as that recording secretary, and making sure that you do include or move all of the information that was in the notice package, copy all the copies of the resolution wordings into the minutes, so that record is retained. Notice packages are not retained past the 2-year mark. So you need to include the minutes, in the minutes of your general meetings, those actual resolution wordings, and then record the outcome of the voting on those. That way you retain that continuity from what was given as notice to owners as to what was decided at the meeting. And 2 types of meetings, of course, council meetings and owner or corporation meetings. Council meetings are planned council meetings, emergency council meetings, meetings of council to hear an owner under 34.1 of the Act, committee meetings, in-camera meetings, shared use meetings, and section executive meetings. So shared use meetings would be something like if you had a shared use between strata corporations for an asset, like a pool that was used by more than one strata. That could be a shared use type situation where these 2 committees get together and report back to their respective councils. You've got committee meetings themselves, so committees that are formed by council that probably have a council member that's leading that committee, maybe to answer a question for council. Provide a broader view on questions council needs answered. We have corporation meetings, of course, annual general meetings, special general meetings, petitioned meetings, information meetings, section meetings, so section strata corporations would have their individual section meetings, and then adjourned annual special general meeting. So this would be if maybe you didn't get quorum. We're going to talk about the difference between terminating meeting and an adjourned meeting later on near the end of this. Strata council meetings. Meeting schedules and frequency and rules are established in the schedule of standard bylaws or within each strata corporation bylaw amendment. So you can amend your bylaws to include a required schedule of meetings. You can have frequency. You can have rules, the way that you're going to conduct business at those meetings. Generally, under the standard bylaws, you'll require 7 days notice to council members of a meeting. So any council member would be able to provide 7 days notice. They would like to hold a council meeting, and then they must inform owners of all scheduled meetings. I always recommend that as soon as the council knows that they have a quorum and they can actually hold that meeting, they should probably notify the owners that the meeting is going to be held. The agenda is determined by the council. A hearing demand must be convened at a council meeting. So again, under 34.1, hearings are conducted at council meetings. Decisions of the council must be reported in the minutes, and owners and tenants are entitled to attend council meetings unless the bylaws have been amended or the matter being discussed admits observers, and that decision is made by a majority vote of council. Decisions at council meetings establish the authority for the corporation and the property manager to manage and operate the business of the corporation. And this would be to do things like spend money, approved in the annual budget or general meeting resolutions and emergencies, collection proceedings. So you're going to record if you're going to be collecting unpaid strata fees, unpaid special levies, you're going to record those decisions. If you're going to be filing a lien or directing the management firm to file the lien, or taking action through civil resolution tribunal or the Supreme Court. Whether you're entering into a contract for service agreements, major repairs, or the purchase or sale of assets, those are all going to need to be reported in your minutes. Filing amendments at land title registry or commencing a court or tribunal action, again, all require decisions. So really, it's a matter of crafting your decisions that's going to make a difference here. And of course, enforcing bylaws and rules, and then when to convene a general meeting to determine the resolutions placed on the agenda. So, council should be holding a council meeting to determine when we're going to call and hold that general meeting, and then what's going to be on that. And that's also a majority vote of council. Limitations on participants or confidential matters. So these are in-camera meetings. You have to be very careful with this determination. Certainly it's up to council, but you can limit the participation of owners in these meetings. These meetings are meant to protect the privacy of owners, tenants, and occupants, not necessarily to protect council from an uncomfortable conversation. But certainly, I think that's a question to ask when someone suggests that the council go in camera to discuss something, is whether or not this discussion needs to be held in the open, and whether or not we'd be violating someone's personal privacy, maybe relating information related to a medical condition or something that would, if disclosed, would identify an owner directly. You want to make sure that you capture the fact that the strata did go in camera and then when they came out of the in-camera session. So recording that in the minutes is a really good practice. And then any decisions that come out of that in-camera session still need to be recorded. And we have an example here at the bottom. At 7 p.m., the council meeting was called to order by the president. 7:05, the council moved in camera to address the ongoing bylaw enforcement matter. At 7:35 p.m., the in-camera session ended. So, of course, there was a lot of discussion that happened during that time. And then out of that meeting came a decision, a motion to instruct the property manager to issue notice of bylaw violation for an illegally parked vehicle that is hindering access and impose fines of $200 per week while the resident continues to violate the bylaw, carried by majority vote. So that captures the record of the decision of council, and that it was voted on and carried by majority vote. So that comes out of the in-camera session. So the agenda at council meetings. The agenda of council meetings does not require the specific wording of any type of resolution. So at a council meeting, you do not need to include anything in the agenda. As a matter of fact, the agenda itself isn't even a record or document of the Strata Corporation that's required to be retained. It's the minutes and decisions that come out of that agenda. So you're going to need to make sure that you carefully manage your decisions and record them in your minutes, because those are the records that are going to count. The minutes will reflect the wording of motions made at council meetings and the results of the votes, whether it passed or failed. So just because something didn't pass doesn't mean you don't record it. Now, often we'll talk to councils and they'll say, well, that decision didn't pass, so we didn't include it in the minutes. But that's not really how this is supposed to work, right? When someone at a council meeting makes a formal motion, then you need to record that's been made, whatever that is. And I often will tell councils the best thing you can do at your meetings is actually focus on the wording of a motion, get that right so it can be recorded properly in the minutes. Everyone knows what's happening, and then you get to discuss and vote on it. Matters at council meetings are determined by majority vote, and the outcome is recorded whether the decision passed or failed by majority vote. Your bylaws might also set out specific requirements for the results of minutes. For example, the council minutes must include the name of the person making the motion, the second of a motion, and the exact number in favor and opposed of each motion. Now, that would be a bylaw that would require that. So you'd have to pass that at a general meeting that would put some conditions on how you report things in minutes. For general meetings, again, we have notice requirements that are set out in the Act, agenda requirements that are set out in the Act, resolution conditions that are set out in the Act, additional procedures and rules of the meeting that may be set out in bylaws. The rules of order are the Strata Property Act, regulations, and bylaws of the corporation. We do have Section 50 of the Act, which I often will lean on when we're dealing with anything to do with a general meeting, because it basically just says anything you do at the meeting is done by majority vote unless a different threshold is required. And we'll be talking about that a little bit more. The results of resolutions and motions must be recorded in the minutes, and matters are decided by a majority vote unless a greater voting threshold is required. And that's Section 50. So general meetings themselves must include agenda items for discussion and voting. So in a general meeting agenda, you need to include that information. It must include the exact wording of the 3/4 vote, 80%, or unanimous votes. It must include any petition items by 20% of the owners. If the meeting is a demand petition, the petitioned items and resolutions must be first items on the agenda. So under Section 43 of the Act, we certainly have strata owners that can demand and petition to demand a special general meeting. And in that section, you're required to deal with those matters first. And then the Strata Council could decide to have added other resolutions because they're forced to hold an SGM at that point. And certainly you could do that. But first on the agenda are the petition items. Additional ended items can be added, like I said. Again, majority vote resolutions do not require specific wording on the agenda. So often you'll see just under the approval of the budget, you'll just have a, council owners are asked to approve the budget, and then the budget and information is required in the notice package. So all of the required information under the regulations and under the Act is contained within the notice package. You don't need to have a formal resolution included on the agenda for those majority vote items. The decisions provide authority for the Strata Corporation to act on matters. So certainly those decisions that are recorded give authority to council. And they give authority to other people too, depending on what those resolutions are. Record the motions and results to eliminate confusion. So certainly with general meetings, always recommend just cutting and pasting those resolutions from the notice into the minutes to make sure that you've captured everything correctly. Here's an example. So motion to approve the proposed budget by Strata Lot 14, seconded by Strata Lot 21, carried by majority vote. That's really all you need to include. You could include the fact that there was some discussion. I would not be capturing any of the real discussion itself. You don't need to. It's a record of the decisions. It keeps it simple, keeps it clean, and it keeps people from injecting their opinions into the discussion itself. Example 2, here's another one. Motion to approve the proposed budget by Strata Lot 14, seconded by Strata Lot 21. Now we have a motion by Strata Lot 33 to amend the budget to increase the contingency contribution from $10,000 to $25,000 for the upcoming roofing seconded by Stratolot 14, and then the amendment carried by majority vote, which at that time then there were no other amendments. So the vote on the budget as amended was carried by majority vote. So that's a clear record of what happened. There was probably a lot of discussion around this, but you're not capturing that. You're just capturing the actual decisions made. Here's another example. So the motion to approve the proposed budget, again, the motion was to amend the budget and increase the contingency. And then here we have Stratolot 14 now requested a precise count. So this was the vote on the budget as amended was called by the chairperson at 8:15 p.m. with 26 in favor, 5 opposed, carried by majority vote. So in these instances, you're going to be, when the precise count is requested before the vote was taken, you're going to be making sure that you include the actual numbers in that. Excuse me. When must a precise count or secret ballot be requested? Request must be made before the vote is taken. Reconsidering the vote within the meeting may result in an unfair influence or intimidation of eligible voters. To avoid confusion, calculate the votes accurately and always take a record or precise count of all general meeting voting. So at general meetings, it's really important to make sure, and it's good practice always to make sure that you're very clear on the numbers in the voting. And secret ballots are not permitted during electronic meetings. So there's no way to do it technically. So best thing we've seen is the amendment to the act that took away that requirement for electronic meetings. So that's fantastic. There's still difficulties though, which is why it's really important to come up with a method of managing your electronic meetings so that you can actually record the outcome of the votes and repeat those in the minutes. Supporting evidence. So the role of minutes in enforcing bylaws. So definitely evidence that you're going to use, whether it's tribunal or court, or even just in your general enforcement of bylaws in the minutes, you're going to need to show that you actually have evidence of decisions made by the council. The role of minutes in enforcing bylaws that we're going to talk about, the role of minutes in collections, the role of minutes in legal, court, or CRT proceedings, and the role of minutes in warranty or insurance claims. So the minutes identify decisions and actions of the corporation and council. They may be critical evidence in supporting a bylaw enforcement process under Section 135 of the Act. And we do see that often in many CRT decisions where the Strata Corporation, Strata Council's gone off the rails and not followed the strict requirements in Section 135, which has pretty much derailed their ability to enforce a bylaw. So you've got to be very, very precise, including recording those decisions. Collection process. So again, before you can demand payment, you're going to need to make a decision authorizing that demand and then filing a lien in court at some point. That decision needs to be recorded in a set of minutes. So it's going to show the court that the Strata did take the steps required, made the decisions by majority vote, and that they proceeded with the lien and then maybe even the forced sale application. A decision to commence a CRT action, including assigning someone on council or somebody to represent the Strata Corporation in that matter to make sure that they have the authority. Decision to commence a CRT action and collect money, any warranty claim process and actions of the Strata Council or the corporation to maintain common property and report claims. So if the Strata is forced to do work while they're doing a claim on the warranty, they're going to need to record those decisions in the minutes so they can prove that they've done those things. And an insurance claim process and authorizing access during an emergency response. So even if you were to access a unit in an emergency, the council needs to make sure that they convey that decision in a set of minutes, that they had to do that at a certain point of time. Best practice examples here. For council and majority decisions where there's no printed resolution, the secretary reads the motion back to the chairperson prior to the vote. So again, that's a really good practice. Spend time crafting your motions, right? It's really, really critical because a lot of times you can eliminate confusion by just having a read through a few times, getting some council to agree on the actual resolution itself or the motion, and then make sure it gets recorded in the minutes. And then a copy of previous minutes of council meetings or general meeting must be available at the meeting for approval. So if you're going to be approving your previous council meeting minutes, then certainly you're going to want to have those at the meeting so someone can refer to them when needed. And so having that record available is really important, whether it's general meeting minutes at a general meeting, or because they're not always included in the minutes, right? Or sorry, not always included in the notice package. Some stratas don't include the last set of minutes. And so, someone's going to need to have them at the meeting. Strata council meetings for approval of council meeting, strata council meetings approve council meeting minutes, and general meeting minutes are approved by the eligible voters at the next general meeting. So voting cards versus ballots. So when you're at the meeting, here's how you're going to be dealing with how you can capture the information needed in order to record this information in minutes. So a voting card identifies the eligible voter. It identifies who's entitled to a ballot. If a secret ballot is called, this would be for an in-person meeting. It identifies who makes motions and seconds. So it's really nice to have the strata lot numbers printed on the voting card so that I know who it is. When we look out at the sea of hands that are raised, there's a voting card raised that has a unit number on it. It just makes for a lot easier procedure. It doesn't have to happen, but certainly it's easier. It reduces voting fraud. So we know that we've actually issued this voting card and it's got the number of the strata lot number on it. So there's no duplication there. And it also can help prevent ballot passing during the meeting. The ballots are the paper decisions of each strata lot on a motion, counted and audited against the registration numbers. So often what we'll do is we'll make sure we have a checklist of those registered voters. And when we hand ballots, we're checking off that those ballots have been given to that particular strata lot. So we know, even though the ballots themselves don't contain the information about who's holding it on there, you certainly would be able to say that we only issued enough ballots per unit at the meeting, so you don't have duplication. And that can prevent more ballots than registrants and avoid problems. And have had that happen at a meeting where more ballots were issued and we had more votes in play than were actually people participating in the meeting. And you want a record of what was done. So the order of the agenda is determined under Standard Bylaw 28. This can be amended, certainly, but this gives you your sort of first glimpse of when we're conducting the meeting. These are the things that we should have in the agenda, and it makes it really easy for you to write your minutes, because you can just paste that into a document and fill in the blanks with the decisions made. So hopefully that's really helpful. Remember, though, strata corporations can amend these. So I recommend that, well, it's good to look at the standard bylaws. You really do want to look at your bylaws and see what's actually been filed, because I have come across stratas that have actually changed the order or tweaked the order or added items. And so you just certainly, it just doesn't look good when a strata council or strata manager or somebody issues a notice package without the actual agenda that's required by the bylaws of the strata corporation in the form that it should be. Call to order. So this is an action that gets recorded in a set of minutes. So the meeting is called to order by the president or VP of council, or a person presented to elect or elected to chair the meeting. And so you just show in the minutes, the meeting was called to order at 7:05 p.m. by John Doe, who's the president. Often we forget to put that in the minutes of meetings. When was it called to order? Who did it? So you want to really make sure that you put that in there. And of course, the time period established by the act or your bylaws. So you really want to make sure, again, always double check your bylaws. Quorum, this is a report. So no decision on this one, but you do want to report this in the minutes. The total number of votes present in person or by proxy, calculate the total number of eligible voters based on 1/3 of the total, or as defined in your bylaws. This certainly is something that can be amended, so be careful. Make sure you just assume that quorum is 1/3 of the total. And we have an example here, 148 eligible voters in accordance with the bylaws. This requires 1/3 or 50 present. And so the meeting was called to order because we had 75 that were registered in person or by proxy and issued voting cards, and that constituted quorum, so we could carry on with the meeting. Then you'd move on to the election of the chairperson. This is actually a vote that you need to take. And so whoever it is that is being elected, you may have requested someone like Joa to come and help chair your meeting. And so you would have I find the best practice is to have the president and the VP move and second that, they're really not willing to chair the meeting and that they would put forward, a name of a CHOA representative or anyone else that's at the meeting to be elected to chair the meeting. So it's moved, seconded, and carried by majority vote. Notice. So again, present proof of notice on the notice package. It's generally best for you to include the date the notice was issued and the method of issue. And so we have that example. Notice was mailed via Canada Post and email were provided to owners on March 1st, 2023. So you've captured that you've met the requirements under Section 45 of the Act. Agenda, approve the agenda. So this is a vote also. We need to make sure that the vote is included in the notice of meeting. So we're going to be voting to approve the agenda. This is not your opportunity to add agenda items that would require something to be voted on. New business as an agenda item is not the opportunity to add new agenda items. It's a place where resolutions such as bylaw amendments have been placed for new business. Approval of the minutes. So certainly that's a vote. That's a majority vote. Corrections or omissions may be added at this time. This is not an opportunity to revote or debate any resolutions themselves. It's just approving the minutes in the form they are. Whether you agree with the previous decisions at the meeting doesn't really matter at that point. They've been made. Reports of council and committees. So this is, again, a report. Doesn't require any voting. You're basically just reporting that there's a president's report or there's some other report. We have an insurance report, which is required, and that usually includes, that's included in the package with a copy of the declaration page, and then information on the policy itself. Again, some minor discussion can happen at the meeting on insurance and those reports, but you might want to take that to the new council if there's more discussion that needs to happen on that. And then you attach all the reports to the minutes. Again, the key is making sure that those minutes capture exactly everything that happened at the meeting. Report on insurance. So here's the report that's required for insurance. Again, best practice includes the binder summary documents, declaration page in the notice package, and then make sure that's transferred into the minutes also. The minutes will show what happened. So again, you can put a little statement in there. You don't need to vote on anything, but the statement can be similar to this one. A copy of the insurance binder coverage showing deductibles and current appraisal rates was included in the notice and copies to owners. Owners and tenants are advised to insure their personal assets and personal risks, including potential costs of strata corporation insurance deductibles if they're responsible for a claim. I know that a lot of the strata management firms have some really good language in there that they include and they just dump in their minutes, which is great. Again, I encourage owners to always review the information in those packages when you get it, because there is a renewal period there, right? So you're going to need to get a copy of the most recent version of that declaration page or information on insurance. Majority vote for those who have voted. So this is a description of the actual how do you determine what a majority vote is. And so we're just going to touch on this. I'm not going to do a ton of different of these, but certainly the definition of majority vote is more than half of the votes cast which have not abstained. So it's not 50% plus one. We hear that a lot. The good example here is below 17 votes cast, so 8.5 if all are residential. This requires 9 votes, not 8.5 plus 1. So when we say 50% plus 1, that's wrong. It's over more than half the votes cast, which is what you want, right? So make sure that you're very clear on how you're explaining and managing that. Otherwise, it would be 8.5 plus 1, right? 9.5 votes, which would be incorrect. So the annual budget, majority votes are for annual budget. Any amendments, the contribution to the contingency reserve fund, any carryover of surplus from a previous operating account. Annual budget may be amended at the AGM by majority vote under section 103.4. Approval of the contingency reserve expense that was recommended in the depreciation report is only a majority vote. I just had a question this morning about that, where Strata had done a 3/4 vote in their AGM package, and it wasn't required. You only need a majority vote to recommend paying for the report out of your CRF. Here's a sort of an example of the annual budget and the minutes. So approval of the proposed annual budget, again, moved, seconded, or motion by Strata Lot 44 to amend the proposed budget. So they're amending the contribution to the CRF. And then the results of these votes, so carried by majority vote, you will often see that CVMV used. That's quite fine. The vote was called on the budget as amended and carried by majority. Again, here we have a majority vote for commercial lots. We do have some calculations down here that can be different. So these are non-residential units. Again, the proper way to manage these voting is to make sure that you have the information on the schedule of voting rights, so that you know that these units themselves will have different voting thresholds. We have at the bottom there in red, in favor 37.40 votes, opposed 22. We had 10.40 votes abstain. The total voting in favor or opposed was 59.40 votes. Multiply that by the 50%. You needed to obtain 29.7 votes. We had 37.4 in favor. That means the budget was approved by majority vote. So very, very different when you're using non-residential units, whether it's mixed use or strata, they can have different voting thresholds. So we're dealing with new business. These are 3/4 votes generally. Examples would be short-term accommodation or prohibition bylaws, building special levy for roofing repairs. Again, new business is not an opportunity to add items to the agenda at the meeting. It is for items that are new business that have been included in the notice. Any agenda items in the notice period that requires a 3/4 or 80% vote or unanimous vote must be included in the exact wording. We've talked about that already. When you're drafting resolutions, remember that the writing of the resolutions is a practice of law under the Legal Professions Act of BC. And if somebody is drafting these resolutions, you need to be very, very aware that experience and knowledge and permitted scope of services are considerations when you're doing these things. Again, miscounting common errors. Definition of a 3/4 vote means a vote in favor of a resolution of at least 3/4 of the votes cast in person or by proxy and who have not abstained at the time the vote is called. Section 170, strata is 173 units. The vote is taken, 79 in favor, 28 opposed. So a total of 107 votes cast times 0.75 equals 80.25. The vote was defeated because you didn't reach the threshold required. Here's a 3/4 vote for residential and non-residential. For example, if you're doing a signage bylaw, you need to have separate votes for residential and non-residential for approval of bylaws. And so you can see the calculations there. Basically, both were carried, but you're going to record those two separate votes in the minutes. Make sure that that happens so that it's very clear that the two votes were conducted. But the resolution was carried by 3/4 vote of both the residential and non-residential unit owners. Accuracy is essential. 100-unit strata passes a 3/4 vote. Here's how you deal with the voting. So 58 votes cast. We had 41 yes, 13 no, and 4 abstained. So that equals, so 41 plus 13 equals 54 times 0.75 equals 40.5 votes. And so it was just a squeaker that you got through. But you do have to consider Section 51, and because you had less than half the owners or less than half the Strata Corporation votes that had approved this resolution, you're going to need to wait a week before you can go ahead and sign the contract. So check out Section 51 when these type of things happen. Again, retain your registration pages, retain all the ballots that relate to 3/4, 80%, or unanimous vote resolutions. If there are concerns over procedural matters and disputes or a requirement for a court application, you can destroy the ballots for pretty much anything else. If the voting quorum at the meeting have voted by majority vote to destroy the ballots. This is one of those sort of governance votes that you're going to take at the meeting. At the end of the meeting, we have a majority vote of the owners. Someone make the motion to destroy the ballots. And so moved, seconded, and then carried. And make sure that's recorded in the minutes, and then they can be destroyed. Council elections, you've got a couple of options here. Certainly, you can do the, you've got 3 variations. Elect those nominated if they do not exceed the maximum amount by a single majority vote. So you can just do the slate. Elect only those who have received a majority of the votes cast, or other options that can be permitted if they're identified in your bylaws. So really you've got the 2 options and then anything else you put in your bylaws. So here's example 1, vote for all nominated. This message establishes that nominees have been elected by majority vote and can be used where there are 7 or fewer council nominated. So again, it's hard to get council sometimes. If you have 7 people that are willing to stand, often we'll just see if the owners are agreeable to just electing those 7 that are nominated or willing to stand. You still need to record though, your decision, right? So that decision gets recorded in the minutes. By majority vote, the owners elected, and then here you go. So moved by Stradalot 6 and seconded by Stradalot 3 to elect those 7 as nominated was carried by majority vote. That's really critical to include in the meeting minutes, is that you actually did hold and conduct a majority vote to elect a council. And then you've got the other option, elect those who received a majority of the votes cast. Again, you're going to deal with the 7 persons nominated. Stradalot 19 requested a secret ballot and moved that those who received the majority of the votes to be elected to council, seconded by Stradalot 25. The ballots were counted, and those receiving more than half the votes are elected to council. So we have the first count, the total. So your first job then is to count the total number of ballots cast, which was 37, determine the minimum majority that the council members would need to hit. And that would be 19. And then you then list who was elected. You can put the numbers there if you want. Certainly you can. I think the use of scrutineers a lot of times allows you not to have to actually list those numbers if you don't want to. But certainly electing scrutineers prior to calling the vote can provide some clarity for owners that they understand that there is someone overseeing the voting and making sure that the count is accurate and that only those that are elected are going to be named. So, election of strata council. This is the third option, which would require a bylaw amendment, would be to elect those 7 that received the greatest number of votes. So that would be something, again, that would require a bylaw to be added. And then ending the meeting under the standard bylaws, general meetings are terminated. The only provision for an adjournment of a meeting is where quorum is not present under the bylaws and the meeting is adjourned for the prescribed period, which is typically, a week later, same time, same place. And then you would have a motion to adjourn the meeting at 8:45 p.m. or a motion to terminate the meeting at 8:45 p.m. Moved, seconded, carried. And that's it. So we got through it in a little longer than I thought, but Heidi, I think we could take a couple of questions if you see some really good ones.
There's lots of good ones. It's a matter of hopefully we can get to them all. A lot of questions about recording of strata council meetings. So questions about minutes for in-camera meetings. Do you record what is said during the in-camera? And then how do you record the votes for a council meeting? In that, do you record the name of the specific council member, how they voted, or do you simply say the number voted yes and the number that voted no?
Yeah, and I think for the first part of that question, there is no requirement to record your discussion of an in-camera session at all. You're only going to be recording in the minutes, and you're only going to be taking minutes of the outcome, right? So, I mean, certainly people could take their own notes. Remember, though, that those could be subject to, some kind of court-ordered action if someone knows there exist. But generally, you don't take minutes or record any kind of the discussion at an in-camera session, and you certainly wouldn't record that in your in-camera decision that comes out of the in-camera session. And so now you would need to look to your bylaws to look to how any decision is recorded in your minutes. So for the most part, if your minutes are kind of silent on this, our best practice recommendation is to do who moved it, who seconded it, and then you would just record whether it was carried by majority vote of council. There's no requirement to list anything else. If your bylaws are different, though, you could certainly have bylaws that say we require the Strata Council to name the voting of each individual council member. Again, making it probably a lot harder to get owners to serve on council with that kind of thing, because often, council have to make some difficult decisions that people may not like. And so again, this is a council decision, right? It's a majority of council. It shouldn't matter who voted for or against, because it's not worthy attacking those individuals. It's just, this is a council decision.
Great. Do we have time for one or two more? Excellent. Privacy, always a question when it comes to minute taking. So we've got questions about how do you record strata lot, unit number, or a person's name in the minutes? Let's start with council meeting minutes, and then if you could address it at a general meeting as well.
Sure, yeah. I'm going to go off what we've, you and I both know this, is that it's the best practice, or actually even the Office of the Privacy Commissioners said, basically, the rule of thumb here is you only provide the information in the minutes that's required to record your decision, so that it's something that can be understood or used for that purpose. See, the minimum needed is really what we're doing, right? So if you are requiring, and consistency also. So if your strata corporation has always used strata lot numbers in your minutes, because that seems to be the best way to keep a record of decision that's easily understood by councils even 2 or 3 years from now, then that's okay. But you should only put the minimum needed in to record what it is you're doing. And that way you're protecting yourselves, and you're also protecting the individuals. Can owners look up strata lot numbers? Yes, but it takes some effort to do that. And remember, strata owners already have the right to obtain copies of correspondence center received by the strata. So really, are your minutes going to be all that private at the end of the day if someone wants to get the information? Probably not. But only record the minimum needed, and that would be for any set of minutes. And so if you don't need to put it in, then don't, is kind of the rule of thumb, right?
Very good best practice suggestion. Approval of the minutes. We've got who approves council meeting. Specifically, the question that came in was, can council approve the AGM minutes?
Council does not approve AGM minutes. Those are done by a majority vote of the owners at a general meeting. So council only approves their own minutes at the next meeting, and the general meeting minutes are approved at the next general meeting. So they're completely separate, parallel tracks, right? So they all relate to governance, but you're on 2 different tracks. It's the owners that deal with their own minutes for general meetings, because those are owners' meetings, corporate meetings.
Great. How about we take one more, and that is, when recording the minutes, should you include the agenda from the annual general meeting? This was the question specifically.
For the annual general meeting, the agenda itself, in the minutes, well, the agenda is the outcome.
Yeah.
So the minutes of the meeting for a general meeting are the outcome of your agenda anyway. So it should be reflected pretty much in your minutes that The agenda is what we're recording here. So the call to order, which is on your agenda, would then be replicated in your minutes, call to order at this time. So you just go through step by step. When I write minutes, I will take the agenda and I will put it in my document, and then I'll fill in what happened for each one of those items that are on the agenda. So they mirror each other. You're not required to include the agenda in your minutes, but the minutes are a reflection of what you did at the meeting, which is your agenda. So
that's exactly what I always suggest as well. Use that agenda to create the minutes. It's a great starting template. I'm very cognizant of time. We have lots of questions. I have indicated my email to a lot of people, but I think we'll leave it at that.
Yeah, I thank you very much, Heidi. Thank you for everyone being here. We do want some feedback on these sessions, so please feel free. And if we didn't get to your question, we're going to certainly try to do so. So send an email to any of the advisors, Heidi, me, anyone, Tony. We'd be happy to try and help. That feedback's helpful too. And thank you very much, and stay tuned for the next one.